Good morning and welcome. I'm Vince Vitkowsky. I'm a partner at Edwards, Wellman and Palmer and at the Center for Law and Counterterrorism, and also the chair of the Society's International and National Security Group. So thank you very much for sharing part of your day with us. Special thanks to Jones Day for making this spectacular facility available to us, to partners Mike Carvin and Greg Katzitz and many others who've supported the Society in many ways, and Donovan for her superb logistical support in getting this all set up for us. We know why we're here today, so let's just, let's get on with it without further ado. I'll do that by introducing the moderator of the first panel, my friend Glenn Zolmacy. Glenn's a captain in the U.S. Coast Guard. Glenn, thank you for your service. He's also chair of the Humanities Department at the U.S. Coast Guard Academy, where he teaches international law and constitutional law. He's been a National Security and Human Rights Fellow at the Carr Center at Harvard. He is a Fellow for Homeland and National Security Law at the Center for National Policy. He's a frequently appearing commentator, who writes everything from op-eds to scholarly articles to books. His book, The National Security Court System, A Natural Evolution of Justice in the Age of Terror, has been well received and informed the thinking of a lot of people on the subject of his morning panel. So without further ado, Glenn.
Thanks, Vince. And again, thanks to Jones Day and to the Federalist Society for hosting this event and for making this space available, and for all of you for coming here. A happy Passover and happy Easter to everybody here. Dean and David, special thanks to you for setting all of this up. As an active duty military officer, I do have to say up front that anything I'm affiliated with today is in my private capacity and does not reflect the views of the federal government in any way, form, or manner. It's great to be here with all of you and with this tremendous panel. It's wonderful to address today some of these issues that have been with us now for over a decade. This truly begins the second decade of the war on Al-Qaeda, and it seems fitting to have a National Security Symposium today to discuss these issues, which haven't been discussed as frequently over the last few months, but will be. And I think we all know it's about to begin in true fashion in the media, in private discussions, and in the presidential campaign as the campaign heats up between the likely two candidates. So it's fitting at this point to begin this discussion, but also to think about or reflect on the past decade, what has changed, and the legal ambiguities associated with the detention, interrogation, and the adjudication of alleged Al-Qaeda fighters is still mired in that same ambiguity that was here a decade ago. We still are not sure what we're doing or how we're doing it or how to proceed. We have sort of a bifurcated approach right now. Some civilian courts, some military courts, some viewed as a law of war regime, some viewed as a law enforcement action, and we're still mired in that debate, unfortunately. And as you know, yesterday, KSM et al. Charges were referred at Guantanamo Bay under this administration against them for their activities in the 9/11 attacks on the United States of America. So military commissions are still being used, much to the chagrin of some on the panel and to the delight of others on this panel. So without any further ado, I'd like to introduce this incredible panel, which I'm honored to be a part of today. We're going to proceed in a fashion of having Ben Wittes from the Brookings Institution begin with his discussion on detention, which he is a celebrated expert on throughout the United States and the world. He's the Senior Fellow in Governance Studies at the Brookings Institution and the co-director of the Harvard Law School Brookings Project on Law and Security. You also know his book, which is very well known and received throughout these circles of national security law, Detention and Denial, The Case for Candor After Guantanamo. It was published in 2011 by the Brookings Press. He also co-writes and co-founded the Lawfare blog, which I believe this event will be aired on at some point here in the near future, and is on the Hoover Institution's Task Force on National Security and Law. The second person that will be speaking today is my friend Nathan Sells, who's at George Mason, Assistant Professor of Law at George Mason Law School. He'll be discussing interrogation. an interrogation from the last decade and what's to look for in the future. He was the Deputy Assistant Secretary for Policy Development at the Department of Homeland Security, and also was counsel and then senior counsel at OLP in 2001-2002, and received DOJ's highest awards for his assistance in the authoring of the USA Patriot Act. Professor Vladeck, another friend and sometimes collaborator and sometimes foe on these issues of national security courts and Guantanamo, but always my friend, is the professor of law and associate dean for scholarship at American University's Washington College of Law, where he teaches national security law and international criminal law, and is a nationally recognized expert on the role of the federal courts in this war on al-Qaeda. He also was a key member of the legal team that successfully argued Hamdan v. Rumsfeld, which again altered the state of play for us for years to come. He's the senior editor of the peer-reviewed Journal of National Security Law and Policy, and is also a senior contributor to the Lawfare blog. He will be discussing the adjudication of the al-Qaeda detainees. And last is my good friend and fellow member of arms, is a commander in the United States Naval Reserve, Cully Stimson, who is at the senior legal fellow at the Heritage Foundation, where he works alongside Ed Meese, was the former Deputy Assistant Secretary of Defense for detainee affairs at Department of Defense in the Bush administration. He has conducted literally hundreds of media interviews, and in fact, Cully, I believe he just came from an interview live on TV moments ago. Prior to his service, he also is a civilian criminal lawyer and has tried over 100 jury trials. Was a criminal prosecutor for a variety of different areas in different parts of the country, including an assistant U.S. attorney right here in the District of Columbia. Again, he is currently still a commander in the Navy Reserves, and we're delighted to have him here today as well. And he will be discussing the detainee affairs with regards to adjudication as well. So truly a great panel. I'm honored to be a part of this, and I think it's going to be a great day to discuss these issues as they become increasingly utilized in the media. And without any further ado, I'd like to introduce Ben Wittes from the Brookings Institution.
Thanks very much. Thanks for having me. I want to preface my remarks here with a caveat, which is that, Glenn asked me to talk about sort of the next 10 years of sort of detention policy. And I'm a little bit humbled in that project by the knowledge that if you'd asked me 10 years ago to anticipate the last 10 years, I think every single thing I would have said would have been wrong. I mean, almost without exception. And maybe I can flatter myself that I would have gotten a couple of things right, but basically I wouldn't. And so I want to caveat everything that I'm about to say with the idea that I know less than anybody else who would venture the next 10 years of this subject is really, talking out of my ear. So consider this a first draft of some thoughts, but not. I actually don't want to represent any of them as in any sense authoritative. That said, here are my authoritative thoughts on detention policy in the next 10 years. I think there are going to be already underway 3 significant themes that we can each expect to accelerate or at least continue. And let me lay them out and then talk a little bit about each. So the first is declining footprint. We're going to be doing less of it for a variety of reasons. The second is that there's a significant, despite the political rhetoric, which is extreme on both left and right, there's a real convergence going on, convergence between the branches, branches of government, convergence between the political parties as to the substance of what we can and should be doing. And the third is sort of a follow-on from the second, which is that the result of that convergence is a degree of institutionalization that I think we've already seen and that we can expect to continue. So let me talk about each of those three and just kind of lay them out a little bit. So the first is this idea of declining footprint. And and this is actually something that a very large number of us got wrong over the last 10 years. When we captured around 10,000 people in the opening months of the conflict in Afghanistan, and then over the course of the Iraq conflict, detained at different times, something around 70,000 people. So it's really, the numbers were really quite vast. It looked like detention in one form or another was going to be a very large part of the sort of policy future of confronting this particular enemy. And what's happened is two things. One is that, detention, is not the most popular thing to do in the world politically. And so there's a instinct not to do more of it than you need to. And that, by the way, began under the last administration, right, which gets rid of 500 plus of the 800 people who had ever been held at Guantanamo. And it's true under this administration, too. Rhetorically more true. And in terms of numbers of people removed from Guantanamo, by the way, much less true. But so dealing with a harder group of people. But it's still true. So that's the first factor that pushes toward a lessened footprint. The second factor is that we have systematically began disengaging from the conflicts and that are causing all this detention. And so when you withdraw from Iraq, and again, this begins under the last administration and continues in this administration, one thing that has to happen is you turn over responsibility for detainees, detention facilities, and processing of those people to the host governments. And a similar process is now going on with respect to Bagram in Afghanistan. The more of that you do, and you can be cynical about that process and talk about it as proxy detention, or you can be not cynical about it and say, hey, we're building up these governments to be capable of managing their own affairs, including their own detention affairs. But one of the consequences of it, however you look at it, is that you end up with many, many, many fewer people in US custody. There is a residue population, and the size of it is a matter of debate, but there is certainly some group of people that we're stuck with. It's equally certain that that group of people is much, much smaller than many of us imagined it was going to be. And because of the nature of the conflict that we're fighting now, which tends to involve the projection of force into areas where we don't have a lot of boots on the ground, i.e. the tribal areas of Pakistan, Yemen, Somalia, we tend to be killing a lot more people than we're capturing right now. And so we're not adding significant numbers of people except in specific theaters where we're also turning over facilities and detention operations to local governments, particularly in Afghanistan. So I think when you put all that together, it is, with the caveat that I would not have predicted this development itself, I don't think we are looking at barring the opening of a broad new front where we're capturing large numbers of people again. I think we're talking about small numbers over the next 10 years, not large numbers. And that has very, very big implications for how politically salient the issue is, how much attention each case gets, and importantly, how necessary it is in those cases to use a detention regime rather than, when you're dealing with one or two people at a time, figuring out a way to make a criminal case, which is, always lets the air out of the balloon when you can do it. The second broad proposition is that there is this convergence going on. And, we pretend it's not happening. So Steve Vladek and I will yell and scream and always in a friendly way at each other about what the right answer to some of these questions are. And, human rights groups yell and scream at people like me, and I yell and scream back. And then we have this huge fight over the NDAA last year, and it's all about detention. And here's the reality, okay? All of that stuff, those are legitimate arguments, and I participate in them, and I thump my chest like everybody else does about them. But here's the reality. The reality is that all three branches of government have gone on record multiple times now saying that a certain amount of non-criminal detention in the counterterrorism context is reasonable. They have all adopted roughly similar principles as to who can be detained, which is to say somebody who's part of or substantially supporting enemy forces is subject to detention. Congress last year wrote that into law. That was more or less the standard that the DC Circuit was already applying, and it was verbatim the standard that the Obama administration, and with one word different, the standard that the Bush administration was using in these courts. So I think you can see in that an amazing convergence from where we were a few years ago on the substantive standards that we are going to use in the course of detention. Now, there are pressures you can imagine coming onto that, I will say, consensus, and there are certainly outliers from that consensus and dissenters from the consensus. It's quite strong now between the branches of government and, frankly, and this is the part that you're really not supposed to say, between the political parties, right? I mean, there is no possible constellation of political forces in the United States today that can get together and say we should be out of the detention business and win. And so I think when you put that together, the three branches of government agree and the political parties agree. I think that is a very powerful constellation of forces that as recently as Boumediene, which is only 4 years ago, there was no vision of that degree of consensus had come together. That leads to the third broad theme, which is the result of this consensus is a degree of institutionalization of these authorities that is, I'm going to state this in as neutral a way as I can. If you're an outlier from the consensus, a dissenter from the consensus, it's very disturbing, right? Because, if you're comfortable with the consensus, it's frankly a wonderful thing. I mean, it's an example in a polarized political culture of we all, put on our horns and lock horns, and we have this great adversarial process in the political arena, in the courts, in the Congress, and we come to something like a joint understanding, and that is reflected now in a quite large body of case law in the DC Circuit and the District Court, and it's reflected in an act of Congress that, for the first, I spent 10 years saying that Congress needed to put its name behind detention policy. And last year it actually did it. Well, that's sort of like, for somebody like me, that's sort of no small thing, right? And it did it with a very, very strongly bipartisan majority, and the president signed it. Not without certain reservations, but he signed it, and his reservations were not on that essential point. If you look at the questions that are now actively being litigated, somewhat to the frustration of people in the habeas bar and people in the human rights community, they're not really the core questions of the legitimacy of detention as a policy. So the case that's up for cert right now and that has the highest chance of getting it, at least in my view, deals with the question, on its face anyway, deals with a very narrow evidentiary. It's a very important question, but it's a question of whether a certain category of intelligence reports get, in the context of adjudicating a detention, a presumption of regularity or whether they don't. It's not a question of can you detain somebody who is part of enemy forces? We've moved beyond that question. And I think if you imagine and I'm going to stop here, if you imagine the degree of institutionalization that has already taken place, I think it would have been very hard to predict a few years ago. And I think it's probably likely to continue, particularly as the declining salience of the issue, because of this lessened footprint, takes some of the political pressure off of it, and we kind of move on to fighting about other things. We really are starting to, and really have a chance to, over the next few years, kind of lock in the consensus that we've developed.
Thank you, Ben. It's a great framework for turning it over to interrogation once we do have them detained, to Professor Sales.
Yeah, I always let Nathan interrogate the people I detain.
Which might explain why I'm to the right of Ben from your perspective.
To the left.
But to the left from our perspective, so take that for what you will. So I'd like to make a counterintuitive claim, and I hope what will be a provocative claim, and that is that our current interrogation policies are undesirable, not from a national security standpoint, but from a civil liberties standpoint. The claim I want to make is that the way we do interrogation now, or actually the way we don't do interrogation now, actually raises more profound and serious civil liberties concerns than a reasonable alternative interrogation regime would. Before I get to that normative claim, though, I want to spend a couple minutes laying out the history and legal context, international and domestic, that surround interrogation practices. I want to describe the current interrogation regime that we have under the Army Field Manual, and then I want to talk about some of what I see as harmful civil libertarian consequences of the current interrogation regime. All right, so here's the history and legal context. The United Nations Convention Against Torture requires all signatories to make torture a crime. Also directs all signatories to proscribe cruel, inhuman, and degrading treatment. What is CID? Well, you can sort of think of it as torture light. It's a form of mistreatment that is severe, but not quite so severe that it rises to the level of categorically prohibited torture. That's the international obligation. The United States implemented those international obligations into our domestic law over the course of about a decade and a half. In 1994, Congress enacted and the President signed what's known as the Federal Torture Statute. It defines torture as follows: one who specifically intends to inflict severe physical or mental pain or suffering. Right? About a decade later, in 2005, the United States enacted the Detainee Treatment Act, which did a bunch of stuff, but as relevant for our purposes, it included a prohibition on cruel, inhuman, and degrading treatment. The Detainee Treatment Act went one step further and mandated that all interrogations that take place under the auspices of the Department of Defense must comply with the techniques spelled out in the Army Field Manual. Right? This goes one step further. What's really interesting about the Detainee Treatment Act is the dog that didn't bark. Notice it's the Pentagon that is subjected to the Army Field Manual restrictions. There's no reference to the CIA. So from a statutory standpoint, the CIA in the aftermath remains legally entitled to engage in alternative interrogation techniques, provided, of course, that they don't rise to the level of torture, which is illegal domestically and internationally, or cruel, inhuman, and degrading treatment, which is also illegal domestically and internationally. The interrogation techniques that the CIA engaged in are well celebrated and well condemned, depending on your perspective. They're at least well known. We can all agree on that. I actually don't find the question of whether those techniques are lawful or not terribly relevant for our purposes today. We can have that debate. We've been having that debate for the better part of 6 years. We can go into the time back machine and have that debate again. But I'd actually like to move the debate beyond that and look at what the law has to say about our current interrogation practices. So what is the current law? Well, in 2009, shortly after taking office, President Obama issued an executive order that closed that loophole. There was daylight between the Army Field Manual techniques, which applied only to the Defense Department, and the prohibition on cruel, inhuman, and degrading treatment, and also on torture. President Obama's executive order extends the prohibition on using non-AFM techniques throughout the entire intelligence community. So CIA interrogators are now subjected to the same restrictions that Pentagon interrogators are as well. So what are those restrictions? They're actually well, quite restrictive. In fact, the Army Field Manual techniques, in many senses, are even more restrictive than the interrogation rules that apply to ordinary criminal investigations. Right? So, for instance, there's a ban under the AFM on using threats. You can't coerce or threaten a source. That might be a violation, the Army Field Manual tells us, of the Uniform Code of Military Justice. So you must in all circumstances take care not to threaten a source. Now, these sorts of threats are actually fairly common in the D.C. Police house about 2 or 3 blocks away. We know that you did it, confessed, or we're going to see to it that you spend the rest of your life in jail. Right? And sometimes the threats are even more vivid than that. We know you did it. If you don't cooperate, we're going to be seeking the death penalty. These are not express threats. I'm not going to kill you now, right? But I'm going to set in motion a chain of events that upon the acquiescence of a judge and the agreement of a jury, you're going to meet Old Sparky, right? So it's a veiled threat, and actually not all that veiled, right? That sort of threat seems to be prohibited by the Army Field Manual. We all know about Good Cop, Bad Cop. Who hasn't seen a television cop drama lately? The good guy comes in, gives you a cigarette, then the bad guy comes in and throws a chair around the room like Bobby Knight at halftime. This technique is permitted under the Army Field Manual, but it's severely restricted. You can only engage in this technique if you get the approval of an 06. Fairly senior officer in the military hierarchy has to sign off on this technique. There's no comparable approval requirement in the criminal justice system. If you're a frontline prosecutor or cop who's interrogating a suspect, you don't have to go to the Assistant Attorney General in charge of the criminal division in Washington, D.C. to get their approval, right? Also, solitary confinement is fairly severely restricted under the Army Field Manual. This is a technique known as separation. In military terms. You can do it, again, but it's frowned upon quite sternly, actually. These restrictions are not only beyond what we see in the ordinary criminal justice system. I think there are actually restrictions that go beyond what is required by federal law and international law. Solitary confinement, a number of scholars have critiqued that as a violation of the Eighth Amendment's ban on cruel and unusual punishments. The courts have not been terribly receptive to that view. Threats, a number of criminal defense attorneys have argued that threatening their clients with lengthy prison sentences coerces them in violation of various constitutional guarantees. Plausible case to be made. The courts haven't generally accepted those sorts of claims, right? So in general, I think these somewhat coercive techniques that are permitted in the criminal justice system that are ruled out under the Army Field Manual probably are lawful. They fall into that gap of space that exists between the statutory prohibition on cruel, inhuman, and degrading treatment and torture on the one hand, and the restrictive Army Field Manual techniques. Right? There's a spectrum of techniques, some of which are clearly ruled out, some of which are clear by law, some of which are clearly ruled out by the AFM. And then there's a gap between there, and that's really what I'm talking about today. So what are the consequences of these Army Field Manual restrictions? Well, the basic idea here is substitution. I teach at a school that focuses on law and economics, so I'll try to keep the economics jargon to a minimum. But the essential idea here is a substitution effect. If you increase the price of one commodity, consumers will shift to other commodities. If apple juice costs $10 a gallon instead of $1 a gallon, people will shift to cran apple instead, right? Or Coke, right? Intermodal competition. So applied to the interrogation context, we see that increasing the cost of interrogation, limiting the circumstances in which somewhat mild coercive interrogation can take place, shifts our counterterrorism apparatus into adopting other alternatives. Well, what are those other alternatives? Well, it turns out the alternatives to mildly coercive interrogation at the hands of the CIA might actually be worse, maybe even be significantly worse from a civil libertarian standpoint. Well, one substitute for coercive interrogation, mildly coercive interrogation, is targeted killing. Right? If we can't question them, take them into custody and ask them questions, we'll simply kill them on the battlefield. And my friend Ben has already averted to this. There is some empirical evidence for the proposition that targeted killing is up, perhaps in response to, although there are other imperatives causing this increase, perhaps partly in response to the more restrictive interrogation rules. Right? There's a lot more drone attacks now than there were 5 years ago. Well, why is that bad? Shouldn't we want to kill Osama bin Laden in his sleep? Well, yeah, we should. But Well, one obvious cost of counterterrorism targeted killing is you can't do counterterrorism interrogation, right? Dead terrorists tell no tales. If they're dead, if they're incinerated in a Hellfire missile, they can't really tell you where the next attack is going to come from. And maybe that's a trade ruling to make. Another downside, though, that should receive very serious attention is the consequences for innocent bystanders. When you launch the Hellfire missile into a convoy, you're not just killing the guy who's making the bomb, you're killing his wife, you're killing his kid, perhaps. So we shouldn't really worry about, at least I don't think we should worry too much about raining hellfire down on our enemies, but we really should worry an awful lot about raining hellfire down on our enemies' families. Targeted killing, to be sure, is a more precise use of force than blunt military force. It's more targeted, to coin a phrase. But it's not 100% perfectly targeted, and there will be inevitably collateral damage. Perhaps mildly coercive interrogation at the hands of the CIA is a price we're willing to pay to avoid the greater civil libertarian harm of collateral damage. Another possible substitute for interrogation by the CIA is interrogation by nasty regimes in the Middle East. I'm speaking here of rendition. If we can't interrogate the people we have captured, we'll simply hand them over to third countries. These third countries, it goes without saying, are considerably more brutal than the United States is. We're not talking about walling. If you're in the hands of the Egyptian security service, walling is the least of your worries. In fact, waterboarding is what happens on a good day when you're held in custody by the Egyptian security services. We're talking about electrodes attached to sensitive parts of the body, serial beatings, fingernails being detached from your hands, truly, truly gruesome and brutal interrogation methods. So this is bad for obvious reasons. If the interrogation, again, mildly coercive interrogation, is being done in-house, we don't have to worry about the consequences of outsourcing interrogation to third parties. The CIA is, believe me, considerably more scrupulous about obeying the international and domestic laws against torture than the Syrians are, right? So again, maybe we're willing to pay a price. Maybe we're willing to countenance, again, mildly, not severely, but mildly coercive interrogation techniques in order to forestall the significantly greater civil libertarian harms of coercive interrogation conducted by non-human rights respecting regimes throughout the country. There's a third harm that I see, but I'm actually out of time now, so I'm going to hold off on discussing that until we get to the Q&A. Here's the teaser. Another consequence of coercive of ruling out all, even mild forms of coercive interrogation, we might have spillover effects. In other words, if we start to change the rules in the Army Field Manual to accommodate the CIA's greater needs for flexibility in using, solitary confinement and Jeff, good cop, bad cop techniques, there's a risk that those new standards will start to metastasize throughout the entire intelligence system, throughout the entire interrogation system, right? And will begin to contaminate more pristine areas of interrogation where we want and demand that interrogators follow the strictest rules and most protective of civil liberties rules. I'll develop that idea later on if you want. If not, we can talk about something else. Thank you all.
Thanks, Nathan. That was terrific. On to Professor Vladeck with the next step in the progression.
Thanks, Glenn. Thanks for inviting me to be on this panel. Thanks to all of you for coming. Let me just pick up actually sort of where I think Ben left off, although I think this will also tie together with some of what Nathan said. Ben suggested there are three themes: declining footprint, convergence, and institutionalization. I want to sort of register my concurrence on the first and third themes, and my very respectful dissent on the second theme, and in my remarks try to briefly explain all the places where I think we don't have convergence, and leave it to you to decide whether we should, and if so, in which direction. So Nathan actually prompted one of them, right? Targeted killing. I think as the recent Operation to Kill Anwar al-Awlaki showed, I don't think there's any convergence when it comes to the scope of the government's authority to conduct targeted killing operations, whether it can apply to U.S. citizens like al-Awlaki, whether it could potentially apply within the territorial United States. The Attorney General, I think, tried to assuage all of our concerns in his speech at Northwestern last month. I suspect he only raised them by suggesting, among other things, that due process is not in any event a requirement of judicial judicial process, and that therefore, even for those who have due process rights, targeted killing does not require anyone other than the executive branch to sign off on it. I suspect there are folks who would disagree that that is a valid assessment of constitutional due process law. But even with regard to detainees, Ben mentioned the case that's up on cert right now. It's called Lateef versus Obama. I think it's true the D.C. Circuit has, as I've written, well, and Ben and I have both written, I think, Ben neutrally and me less neutrally, about the D.C. Circuit's jurisprudence arising out of Guantanamo. It has, I think, largely coalesced around a series of core principles about the scope of substantive detention authority, the evidentiary standard, the procedural safeguards. Lateef could upset all of that. I mean, the specific question in the Lateef case is actually a fairly technical one, as Ben says. It's whether government intelligence reports are entitled to a presumption of authenticity in habeas proceedings. But sort of lurking behind that is the whole, I think, infrastructure. What is preponderance of the evidence the appropriate evidentiary standard? What are the rules governing admissibility of hearsay in Guantanamo habeas proceedings? So, if the justices take Lateef, and they might, I mean, I do think it's the best candidate since Boumediene, I don't know that we can accept that the D.C. Circuit will really have had the last word. But otherwise, I agree, right? I think the Guantanamo cases are legacy cases and really are sort of largely going away. There are two other fields, right, for our detention operations. There are extra domestic detention operations that don't result in detention at Guantanamo. As Ben points out, that is a dramatically reducing set, almost to zero. And indeed, if we finally pull out of Afghanistan, you may see sort of a formal reduction to zero with regard to overseas detention operations. But what about domestic detention, right? I mean, it is currently the law, not the law, it is currently the fact that there are no citizens or non-citizens being held by the military inside the domestic United States. But as the debate over the National Defense Authorization Act from last year revealed, I think there's a lot of public debate about whether it's ever appropriate to detain individuals domestically within the United States. And indeed, I think the whole reason why there has been such fierce opposition to the NDAA is a belief, whether it's accurate or not based on the text of the statute, that the NDAA authorizes such detention. So I think it's hard to say that there's convergence there. What there is at the moment, no cases. And that's great, but I think that doesn't mean that 5-10 years from now we can be so sure the law is settled. With regard to military commissions, I think Cully's going to say more about them. Let me just sort of flag a couple of quick points. Jack Goldsmith, who I'm sure most of you know, has been all around the media world, including The Daily Show now, which I guess is that's the last one, right? One star on The Daily Show, talking about his new book. And one of the points he makes in his new book is that there has been this convergence, this coalescence around military commissions, as evidenced, for example, by the referral of charges in the 9/11 case. Let me suggest there are a couple places where that's not true. So, for example, with regard to whether military commissions may constitutionally prosecute the offense of providing material support to terrorism. Right? So Congress in 2006 in the Military Commissions Act specifically defined, I think, 25 or 26 substantive offenses that military commissions could try. The theory that Congress pursued when it enacted the bill was that it was defining offenses against international law. It was exercising the power to recognize violations of the laws of war. And material support was supposed to be one of these offenses. Hamdan, whose case I worked on when it was before the Military Commissions Act, was re-indicted, re-prosecuted under material support, and convicted. His post-conviction appeal is actually going to be argued in the D.C. Circuit on May 3rd before an incredibly defendant-sympathetic panel of Santel, Ginsburg, and Kavanaugh. I'm not sure how that's going to come out, but the question actually is fairly significant. And why is the question significant? The theory that the DOD litigated the case under was that Congress has the power to decide for itself what is and what is not a violation of customary international law, of the laws of war. The government has now shifted its theory. Right? In its briefing in the D.C. Circuit, it has said, no, it's not that it's a violation of international law. It's that it's a violation of the domestic common law of war. We certainly don't have the time to get into that argument and whether it's convincing or not. But by shifting the terrain, they have reopened the question of whether, in fact, Congress can define such offenses, whether even if Congress can, it can subject them to trial in a military commission. And so I think the Hamdan case actually shows how there are still these large questions out there. With regard to sort of deeper questions of constitutional rights and process and evidence in the military commissions, I'll just put it out there, rather bluntly. Does the Sixth Amendment even apply to the military commissions at Guantanamo. That wasn't an issue in Hamdan's case. It very well might be in the 9/11 case. Does the Fifth Amendment apply with regard to due process? Ray Randolph is on record as saying he doesn't think so. Will the rest of the D.C. Circuit agree? So, we may have convergence that military commissions are feasible. We may have convergence that military commissions are, in some circumstances, permissible. But given these questions, I'm not so sure we can say, yay, military commissions. Last, before I sort of shut up and Cully can explain why military commissions are, in fact, perfect. The other piece of this is criminal prosecutions, right? So one of the classical arguments against or for military commissions has been the perceived unavailability, or at least difficulties, of prosecuting future terrorism suspects in the Article III courts. And let me just briefly highlight what I think are a couple of developments suggesting maybe we actually are having convergence toward criminal prosecutions. So first, right, the Supreme Court in the Humanitarian Law Project decision in 2010 beat back, right, a very sort of significant constitutional challenge to the scope of the material support statute. Chief Justice Roberts' opinion for the court is, I think, a sweeping endorsement of the civilian material support statute, which is how the government prosecutes most of these terrorism cases in the criminal courts. The Chief Justice says it doesn't violate the First Amendment, even though it seems to prohibit various forms of otherwise constitutionally protected speech. The Chief Justice says these terms are not vague, even though it might be true that writing an amicus brief on behalf of a designated foreign terrorist organization is prohibited by the statute. So with a statute that large, right, and that broad, I don't think it's surprising that the Obama administration, like the Bush administration before it, has seized on this particular statute as its anti-terrorism weapon of choice, right, to go after most of the cases that it wants to. That doesn't mean that there aren't issues about the scope of the material support statute, but the Supreme Court, I think, at least for the moment, has settled the big ones. The other piece is, right, we have increasing extraterritorial application of other criminal statutes. So it is increasingly the case that when we pick up terrorism suspects elsewhere outside the United States, we have the civilian courts as a meaningful, available option in ways that we might not have before 9/11. There are, of course, transfer restrictions for trying the Guantanamo detainees in the United States, but it's actually, if we parse the language of the National Defense Authorization Act, it's actually not that hard to try a newly picked up suspect outside of Guantanamo in the Article III courts. So one of the responses you often hear is, but there are intelligence gathering problems, right? That the Article III courts get in the way of the government's ability to gather intelligence from suspects. And I just want to suggest briefly, I'm not so sure that has proven to be true thus far. So you hear a lot about Miranda, right? But the public safety exception is there, right? The Justice Department has suggested it's quite happy to use it in an appropriate case, right? There's been no suggestion that it wouldn't be used in an appropriate case. With regard to, use of evidence from foreign intelligence services, right? The Fourth Circuit in the Abu Ali case approved a rather remarkable and unprecedented procedure for allowing Saudi intelligence officers to testify in an ordinary criminal trial by two-way video hookup. So, I think the courts are making these accommodations that largely put the critiques to bed, and indeed with an even odd side effect, where now it's actually that sentencing is even better for the government in the Article III courts than in military commissions. Two of the highest profile post-9/11 terrorism prosecutions in civilian courts, the Abu Ali case, the Jose Padilla case, the only error that the Court of Appeals found on appeal was that the district court had imposed too lenient of a sentence. Right, and returned both those cases for resentencing. In contrast to the sentencing in the military commissions, the irony is actually that, the fastest way out of Guantanamo, the fastest way out of terrorism detention, is to be tried by a military commission. Anyway, let me sort of close with just a case study, which I think drives this point home. You may be familiar with the case of Warsami, right? Warsami was an individual picked up by the U.S. in the sort of Gulf region on the high seas and accused of piracy. Right? He was held allegedly on a naval ship for 2 months and presumably subject to various of the interrogation methods that Nathan alluded to, before he was transferred to New York to stand trial on ordinary civilian criminal charges of piracy. Now, I suspect there are folks, I may be one of them, who sort of worries about the whole 2-month indefinite detention piece of that. There may be folks who say we should just send people like Warsame to Guantanamo. But the reality is he's standing trial in the civilian court. There has not yet been a procedural sort of obstacle to his trial that's been raised. And I think, in the long term, that's the paradigm we should be looking at, right? If you really have someone who has intelligence value, very short-term detention for purposes of interrogation and intelligence gathering, and then use the Article 3 courts. That's why they're there. I think we'll probably fight over how short-term is, but that's a detail. So, I think that's where there might be convergence. On the other points, I guess Ben and I will just continue to at least, faux disagree.
Just to clarify, when I talked about convergence, I was speaking narrowly about the authority to detain, not about targeted killing or about military commissions. So I actually don't disagree with Steve that there is much less convergence with respect to either of those areas.
See, faux disagreement.
Thanks very much, Steve. Cully?
Thanks, Glenn and Dean, for the nice introduction, and to Jones Day and, of course, the Federalist Society. And I, too, will start with the necessary caveat, especially since my ultimate boss is here, the distinguished admiral in charge of the reserve component of the Navy JAG Corps. I'm speaking as a heritage scholar only. And so despite the fact that I've had the privilege, like Glenn, of wearing the uniform for over 20 years and been a prosecutor and defense attorney and now judge in the military, I'm speaking solely as a heritage scholar. And, of course, from my experiences in running the detainee policy in the Bush administration when we debated and ultimately published the Army Field Manual and had these very similar debates within the confines of the Pentagon and other buildings around Washington, and then also was in Geneva in May of 2006 when we presented our second periodic report on the Convention Against Torture, and we can go into what is cruel, inhuman, or degrading treatment or punishment during the question and answer phase, but I can tell you, having been in Geneva and looking across the table and then in the hallways of this Grand Palais in the United Nations, there are wide divergent views of what is cruel, inhuman, and degrading treatment and punishment, and not just limited to what was discussed today. Obviously, with the referral of the charges yesterday, and I suspect he's being served with the charges today, which will trigger the 30-day clock, many will expect a hive of activity. I suggest that the exact opposite will happen. He'll be arraigned within the next 30 days. There'll be a period of perhaps a series of pretrial motions. I suspect we may see more than 100 pretrial motions. That could take years. And if there's a trial, it will be during Romney's first term or Obama's second term. And I say if because we don't know what KSM is going to do. He, of course, tried to plead guilty before that, but there was an open legal question as to whether or not you could plead guilty to a capital offense in a military commissions case. Why was that true? Because in courts-martial practice, you can't plead to a capital offense, even though you can in federal court and state court. Congress has changed those rules now that allow you to plead to a capital offense in military commissions, which means you plead to it, but then there is a full and robust sentencing proceeding, which, in my estimation, would take a long period of time. And then the members will decide whether or not, members, I mean jurors, will decide whether or not he receives life without parole or the ultimate punishment. I'm going to stick with the Ben Wittes format here, and I have 3 points to make. I won't be as eloquent as Ben, but I'll try. But I would commend to each of you not only Ben's blog, which I think is the finest blog and the most informative blog out there in this area of public policy and law, but then in particular a series of speeches by the Chief Prosecutor, Brigadier General Mark Martins, who all of us up here know, who has, I think, in contrast to all of his predecessors, all of whom did the job they thought they should be doing, and I think the best job they could, really has laid out for the world to see, and especially the American public and policymakers, the reasons why one would want to use military commissions in certain instances, how these commissions are not your grandfather's commissions or even the commissions from the early 2000s after 9/11, and they're marked improvements from the 2006 military commissions. Act. And agree or disagree, what you can agree on is that that series of speeches is an important framework for understanding what, quite frankly, is not a very transparent system of standard military justice, just because we go about our way in the military justice system. We don't try to be secretive about our military justice system. It's just that it's a component of our military operations, and that is what it is. So my three points that I'd like to make are these, and then I'll go into them a little bit. One is a comparative analysis of the rules between military commissions, federal courts, and international tribunals. And secondly are the key reforms from the 2006 to the 2009 Act, and really what the rub is between military commissions and those that prefer federal courts. And by the way, I hate to disappoint my friend Steve. I'm not going to say that the military commissions are perfect, because no criminal justice system is perfect. I'm actually an all of the abover. I have profound respect for federal courts, as I've had the privilege of prosecuting as an AUSA in federal court, and military commissions, and their flaws in each. And then the third point, briefly, are future challenges. And Steve, I think, stole a little bit of my thunder, because I think it is an open question as to whether the material support statute is appropriate for military commissions. So let me start with my first point, comparative rules analysis. Step back, or step up 50,000 feet and look down and pretend you're from a different planet. And you're being introduced by your host, and your host is talking about various things, and then your host tells you that there's this thing called a criminal justice system. And essentially what your host would tell you is that a criminal justice system is a system of rules. That's it. Rules of conduct by which people can have a fair adjudication of their case before a set tribunal. And so I think if you have the time and you're interested, it would be important for you to take a fair and objective look at the rules that the Military Commissions Act of 2009 have, which are essentially 99% of the rules they had in the 2006 Act, with 5 key modifications. They're far different than the Military Commissions Order, which came out right after 9/11. And I can tell you, having had the privilege of working in all of those systems, except military commissions as a defense attorney or prosecutor, that if you look at those rules, and I'm going to tick some of them off just so you don't have to spend your time doing what I'm suggesting you should do, that the rules compare favorably. And in fact, I would make the argument that they are fairer than the international rules in the International Criminal Tribunal of Rwanda or Yugoslavia and the International Criminal Court. And that's why Heritage put up a comparative rules analysis just in chart form, and now the Military Commissions Office has done the same. If you go to mc.mil, you can see this comparative analysis. And I'm just going to tick off some of them because it may come as a surprise to some of you. Obviously, in each of the military commissions, courts-martial and Article III courts, the accused is presumed to be innocent unless proven by legal and competent evidence beyond a reasonable doubt. Obviously, the prosecution bears the burden of proof by reasonable doubt. Each is provided defense counsel, and in federal court, as you know, there's a federal public defender, and the accused can seek civilian counsel. And in fact, in military commissions, especially in the death penalty context, they're provided what are called learned counsel. And I can tell you, if you look at the bios of these learned counsel, like Rick Kamen from Indianapolis, who's representing Al Nashri, the USS Cole bomber, or David Nevin, who's representing KSM, these are some of the best defense attorneys our country has ever produced, period. They've tried the hardest cases, they've taken the most unsympathetic cases to trial, and they are the best of the best. And that is the way I believe it should be. There's attorney-client privilege. The accused, of course, is entitled to be at his trial unless he's disruptive, and then the judge, through his own plenary power, can excuse him for portions of the trial. That's true in all of those cases. You have the right to cross-examine witnesses, freedom from double jeopardy, which, by the way, in the international tribunals, if the government loses, they can take an appeal. We reject that as Americans. We rejected that principle a few hundred years ago. The right of an assistance of an interpreter at no cost to the accused, protection against compulsory self-incrimination, challenges during the jury selection process in all three tribunals. In courts-martial and in military commissions, it takes 2/3 of the jurors to convict. If the sentence, because jurors sentence in the military, criminal justice system, and commissions, if the sentence is 10 years or more, it takes 3/4 to convict. And if it's a capital conviction, then it requires unanimity across the board. There's appellate review. Military commissions cases go to intermediate military commissions, a court of appeals, then the D.C. Circuit, then ultimately potentially to the Supreme Court. Public access to the trial. The prosecution must turn over exculpatory evidence to the accused in those three tribunals. Now, hearsay is what a lot of people who criticize military commissions talk about. But if you look at the hearsay rules, where hearsay is prohibited unless the witness is unavailable, and then only when noticed to the opposing party, and only if it is material, probative, and reliable in the interests of justice to be served by the admission of the hearsay, that standard is substantially similar to the standard in international tribunals. So the same people that criticize commissions, I don't find them criticizing international tribunals, perhaps for a variety of reasons, and I find that a little bit disingenuous. And then there's the issue of torture. And in the KSM 9/11 context, obviously there's an allegation, there's public acknowledgement by the CIA that KSM was waterboarded, and that some of the other high-value detainees from the CIA's program were subjected to enhanced interrogation techniques. But I would suggest to you that the evidence that the government intends to use, because now statements adduced by cruel, inhuman, degrading treatment or punishment are prohibited by law in commissions, would be substantially the same case the government would put on if the case was tried in federal court. And that's what the chief prosecutor has said, and that's what he intends to do. So I think any comparative rules analysis would show you that the rules are taken almost identically from the military courts-martial rules, the rules for court-martial, military rules of evidence, and that under the circumstances, remember Hamdan said that the rules needed, Hamdan, the 2006 case, which struck down the Military Commissions Act, said, among other things, that under the doctrine of practicability, the Congress could peel back certain rules given the circumstances. And I think these rules are an appropriate accommodation. I don't think they're perfect, and I think they'll be tested, but I think that they're certainly fair. On to my second point, the two big reforms in the 2009 Act, which I was all for, and in fact was against the 2006 Act when I was in office, when we rewrote it, for lack of these particular rules, was how hearsay is treated. In the old 2006 Act, essentially the opponent of the hearsay, Steve is trying to put in some hearsay. He's the government counsel. I know that makes you very uncomfortable. You're the prosecutor. I'm the defense counsel. Judge Sales over here says, he's very distinguished looking, Mr. Stimson, tell me why Mr. Vladek's hearsay is unreliable. Well, how the hell am I supposed to know? I don't know how it's unreliable, but the burden was on the defense to prove it's unreliable, or the opponent to prove its unreliability. And in practice, what the judges were doing was doing what they always do. And they said, well, yeah, I know that's the way the rule's written, but Mr. Vladek, come on, give me something here. How is this hearsay that you're attempting to put in reliable? And so that change, which was key, I think, essentially codified existing practice to some extent. And so that was very helpful and I think necessary. And then the issue of how you deal with classified evidence. There's this federal rule of evidence called Federal Rule of Evidence 505, the Classified Information Procedures Act. And the original rules in military commissions deviated from that in some significant ways. And I think that the new 505, the Military Commissions Rule 505, is substantially similar, although there are some slight differences, not many, from the federal rule. And I think that will be challenged in military commissions, and probably rightly so, but I think that the accommodations are probably necessary. Now let's thirdly talk about the future challenges. I think there's two future challenges. They fall into two categories. One is legal and the other is logistical. The legal ones, I think Steve very rightly pointed out that The material support is an open question, whether that can be considered a part of a military commissions context. There will be Sixth and Fifth Amendment challenges. But I think the litigation risk is less than it was in the past. And I think that because if you look at the wide body of law that has been litigated in military commissions, some of these questions have been at least partially resolved, and I think the answers to many of them have been resolved. And so I think the litigation risk is less than it was in the past, but there still is one. The second is, in reality, how are we going to deal with the issue of the defendant who wants to go pro se, wants to represent himself, especially if the proceeding has already started and you're further down the road in trial. Remember that that's happened in other cases in federal court, but here in military commissions, I think that the degree to which the judge exercises plenary power to appoint standby counsel, what access to evidence that the various accused who obviously don't have security clearances will have to classified information or summaries of classified information, that will be a dicey and I think tricky question, and I suspect there will be a litigation on that. The last thing I'll leave you with is this, and this is a logistical point. I think the government has done a very good job, and this convening authority especially has done a good job making sure, in the interest of fairness, that the defense counsel, the defense team are adequately resourced. There are complaints, but I'm a defense attorney. I always complain about the stuff from the government, and so I think there's a natural level of whining by us, by me, when I'm representing people. You didn't give me this discovery. You didn't give me this on time. You didn't give me this early enough, and that's normal and healthy. In the death penalty context, they're given mitigation experts up front, which is very, very helpful and I think quite necessary for the proper preparation, pretrial preparation for a potential death penalty case. And they've been given learned counsel, the folks I mentioned, and I suspect you'll see additional learned counsel cleared. Getting them the security clearances they need in time is still a problem. Declassifying information takes time, and I still don't think they've solved the logistics of doing that in the speed in which many would hope it would happen. And then finally, I think there's an imbalance now. There's an imbalance between, in some cases, not all, between the provision of outstanding, world-class, the best defense counsel our country has produced, civilian learned counsel, and government counsel who are well-meaning, patriotic, hardworking, detailed these cases, raised their hands, volunteered, but many of them don't have anywhere near the trial experience, not even close to the trial experience that the learned counsel have. Now they have the backup of the entire Department of Justice and the U.S. government, so I don't want to suggest that there's an imbalance in resources, but in terms of trial experience, there's a massive imbalance. One of the lead prosecutors on the al-Nashri case, the USS Cole bomber, delightful person, patriotic person, hardworking person, has been working on the case forever, has tried 2 cases as a military prosecutor. That's an imbalance that I'm talking about. And if these cases become contested, and they'll go on for weeks, if not months, in court after the pretrial motions, you will see the qualitative difference between somebody who hasn't tried a lot of cases and people who have spent months in trials and tried the toughest cases out there. That may not even play out because there may be pleas. So I think there's a lot on the table for the question and answer period, and turn it back over to our moderator.
Thanks, Cully. That was terrific. And to all of you, thank you so much. I think a round of applause before we... I appreciate you sticking to the time limits. It's never easy to keep a former Washington Post reporter, 2 law professors, and a commander in the United States Navy within the time limits, but I think we've done that to give us sufficient time. There's certainly tons of questions that are to be asked, so we do have a microphone. David is up here. If someone would like to go up and start with questions, please feel free to line up. While we're doing that, I'd like to use my prerogative to just go down the line with quick hitters, if I could, while we're getting people lined up for quick questions for each of the great panelists. For Ben, quickly, the 50 to 60 still in permanent detention at Guantanamo Bay, what do we do with them? Are they just going to be left there without charge, without process until they die?
Well,
that's a quick hitter.
Yeah, it's substantially more than 50 or 60. I mean, it's 170-ish now, 171, I believe.
The administration has said they'll keep 50. Well,
the administration has said that if they can try everybody they would like to try, either in federal court or in military commissions, and if the situation in Yemen improves to the point that they can repatriate 60 people whom they would like to repatriate to Yemen if they were repatriating people to Yemen, which they're not, they would have 48 people left, a couple of whom have died, so it's probably 46. I think the verdict is yet out on how many people they will be able to bring to trial. And the verdict is certainly yet out on whether the circumstances in Yemen will, in the medium term, be more permissive than they are today for the repatriation of large numbers of people to Yemen. And in the meantime, you have really an additional constraint that has opened up, which is that Congress has passed a piece of legislation and repassed it at least once now, that basically says you can't remove anybody from Guantanamo without a set of certifications from the Secretary of Defense that frankly are nearly impossible to make in a lot of cases. And so I think as a practical matter, the population that you're dealing with at Guantanamo, barring significant changes in Yemen and significant changes from the United States Congress, is a population of 171 minus whomever you can bring to trial. There may be individuals within that whom you can make certifications about under certain circumstances or whom you can find accommodations for. There are some individual cases that are quite sympathetic, frankly, and that we ought to be trying to figure out ways to resolve. And then there are cases that we should be thinking about, as we, there are geopolitical considerations that you might take into account. We're in talks with the Taliban to de-escalate the conflict in Afghanistan, and there have been talks of prisoner exchanges in the context of that. I don't know whether those will come to anything, but those are certainly the kinds of things that happen now and then. There's going to be a large residual population, small by the standards that we've held people in the past, but of the 171 people at Guantanamo, we're going to be hanging on to a bunch of them for a good long time. And the administration has set up, and in part of the convergence that I described earlier, Congress has essentially ratified in the NDAA, this has gotten very little discussion, a review process for those detainees who have are slated for long-term detention and B, who have lost their habeas cases. That review process hasn't really gotten off the ground yet, but I think that will be interesting to watch what happens with that as those proceedings get off the ground. That's going to be the mechanism that the executive and legislative branches have gotten together and provided process for that residual group of detainees. And to be honest, there will be as the attenuation of the conflict, and this is a complicated issue, under the AUMF becomes more pronounced, I think you will have some successive habeas petitions from people who make the argument that, hey, even if my detention was lawful 5 years ago, I can't be part of Al-Qaeda anymore because Al-Qaeda's been, defeated, disrupted to the point that it doesn't really exist. And I think you will have those cases will start bubbling up, particularly the more people like Leon Panetta talk in public about the strategic defeat of Al-Qaeda having been either nearly achieved or achieved.
Thank you very much. If you could just say your name and where you're from, who you're affiliated with.
Sure. My name is Tyler Baldwin with the Defense Department. This is a question for Professor Sales. Your remarks on coercive interrogation, it seemed to me that the assumption you were making was that coercive interrogation produces accurate, actionable intelligence. So I guess my question to you is there a tipping point, a threshold of accuracy where your theory would change? Like if, for example, 50% of information produced via coercive interrogation was inaccurate, would that somehow change your thought process? Because, especially from a civil libertarian standpoint, you have someone you're interrogating coercively under coercion they give you a false name, causes a targeted killing of an otherwise innocent person, isn't that worse than just one targeted killing in and of itself?
Right. So the big question here is reliability. How reliable is the intelligence you glean from non-coercive interrogation, from mildly coercive interrogation, from severely coercive interrogation? This is an empirical question, and I actually don't know the answer to it. What I can say is that enough smart people who have looked at this issue have said, yeah, we think that using mildly coercive interrogation, actually they say using even severely coercive interrogation, yields intelligence gains. I am not 100% persuaded that that's the case, but I am persuaded that there's a reasonable probability that that is the case, and that probability is large enough that we shouldn't categorically rule out things like good cop, bad cop, or solitary confinement, or threats or yelling, right? Let me say one other thing. So I think that the false positive concern that you raised is less likely to be a problem in the intelligence context than it is in the ordinary criminal justice context. The reason for that is because inaccurate information is less valuable to an intelligence official than it is to a prosecutor. Right? Suppose a prosecutor gets a confession from a suspect and the confession is false, right? It's not Jeff who killed the guy, it was Jim. Right? That information is still valuable to the prosecutor because the prosecutor can go to a jury and say, Jeff did it, not Jim, even though that's not the case. But false information of that sort really isn't all that valuable to intelligence officials because the goal is not to put somebody in jail. The goal is to prevent the next attack. Right? False information doesn't help you prevent the next attack. So there's a built-in sort of self-interest to verify the accuracy of intelligence information that is stronger in that context than I think is the case in the criminal justice system. Of course, the criminal justice system always has an incentive to do justice, and part of that is figuring out if the confession is accurate or not. But I want to suggest that the incentive to do so is perhaps stronger in the intel context. So I'm less worried about the false positive problem here than I am in other settings.
Thank you. Professor Sales, I follow on while we're waiting for the next, is the reciprocity issue. One of the items you didn't touch on, several members of the armed forces here, the armed forces has a concern frequently with the idea of reciprocity. If we do this to them, then they will do that to us in some context or use it as precedent for future conflicts. Mm-hmm. How would you respond to that, Professor?
Yeah, that's an absolutely important concern. And I think it explains why Army Field Manual techniques, interrogation techniques, are proper for the armed forces, precisely because of those reciprocity concerns. If American soldiers get captured by the Chinese or the North Koreans or the Iraqis or whoever we're in a hot war with, we want to make sure that they have the right rations, that they're given access to athletic equipment, scientific experiment tools, all the sorts of rights that are spelled out in the Geneva Conventions. And one way to ensure that our soldiers get those benefits is that we extend a reciprocal set of benefits to those we capture. And those benefits can include exemption from more coercive interrogation techniques. So absolutely, that is one of several reasons why the Army Field Manual restrictions are desirable in the military context.
For lawful combatants.
For lawful, right. The reciprocity issue looks a little bit different in the context of intelligence interrogations because typically if a spy gets captured by the Russians, there's no expectation that person is going to be given the Geneva Convention benefits. And if a spy gets captured by Al-Qaeda, that's a pipe dream, right? So you have less to gain in the intelligence context from staying your own hand, because your decision to stay your own hand in the intelligence context is less likely to trigger favorable treatment by your adversary. Staying your own hand does produce benefits in the military context, which is why I think the Army Field Manual techniques are appropriate there. I'm less convinced that tying your own hand in the intelligence context is going to induce Al-Qaeda or other intelligence agencies to reciprocate.
Great. Mr. Stimson, follow up?
I'll just add to Mr. Baldwin's question and Nathan's point that as we were considering the 19 interrogation techniques in the Army Field Manual back in 2006 and deciding various issues related to that. One of the strongest voices we heard in the room, and I won't be able to say who represented this, was the reciprocity issue. And of course, the point we kept coming back to is the Army Field Manual, it actually has a longer name, but everyone calls it the Army Field Manual, was designed for interrogators in the military who go to the basic course at Fort Huachuca, and it applied to all detainees in DOD's control or effective control, which theoretically meant that people outside the DOD could come in and interrogate DOD detainees, but they would have to use the Army Field Manual techniques. It was not meant to cover the whole spectrum of potential lawful interrogation techniques. And so one of the questions that individuals raised, me in particular, was, well, why isn't lying a specific technique? We lie routinely to suspects in the criminal justice system. It's an effective technique. By the way, Mr. Worthington, we found your DNA on the knife that was found at the scene. Come on, just give it up and we'll take it easy on you. And the pushback was that the false flag technique is akin to lying, basically saying, hey, we're actually Egyptian interrogators, we're not American interrogators. And it was a version of lying, but that it was not doctrinally used in the past, and therefore other agencies, if in their programs, could use lying or other techniques. And so I think that the conversation that we have not had as a country, and certainly here in Washington, is what additional lawful techniques are there, like lying, et cetera, should, for example, the HIG, the High Value Interrogation Group, be able to use. And I would further suggest, and I'll leave it because I know you've been standing there very patiently, that if they ever take up that mantle, and I doubt they will, that it shouldn't be done, ultimately, the techniques decided by the public. It should be decided behind closed doors, and we shouldn't be tipping the enemy off to what those additional lawful techniques would be, like lying.
Thanks, Cully. Ma'am, just where you're from and your name?
Yes, sir. My name is Sylvia Ross. I'm just an attorney from Virginia. I'm interested in this area because I served in the military for 8 years. And my question is along the lines of reciprocity, and it's for Mr. Sales, but certainly anyone else to address. I appreciate your economic analogy that there are logical consequences or things we don't think about are the natural outproduct of making shifts. And my question has to do with, are there any precedents we're setting here internationally or nationally that are harmful to U.S. citizens ultimately, or public officials, in the sense if we find ourselves facing those types of situations, if someone picks up a U.S. citizen for piracy, and I'm curious, if we turn people over to third-party interrogators, how can we lead as a nation and set the example and not harm our people by setting precedent for other nations to follow a bad example?
Right. Well, so I take the point and second the point and agree with it. And I think that actually reinforces my argument that one of the things that we should be aware of when setting our interrogation policy is how will limits that we impose for civil libertarian reasons, how are those going to affect the big picture allocation and distribution of civil liberties for non-Americans and for Americans alike? This is one reason why I think it's better for us to engage in, to tolerate mildly coercive interrogation techniques by the CIA than to substitute for that rendition to Egypt, rendition to Syria with the attendant horrors associated with interrogation by those regimes. One reason why we want to prevent that substitution from taking place is because for humanitarian reasons we don't want even our adversaries to be subjected to that sort of brutal treatment. Another reason why we want to prevent that substitution from taking place is the concern that you identify, which is if we establish an international norm that rendition to third countries is acceptable for brutal interrogation, then Americans that are picked up in France, for instance, which does have a strong track record on human rights and human dignity, might find himself in Algeria, right, being brutally tortured there. So for self-interested reasons, there are other good reasons why we don't want to establish rules that seemingly respect civil liberties, but over the long run may actually help erode them. Right? Actually, let me just say, usually when I give this talk, I get the question, well, okay, what kind of techniques do you want? And I'm surprised nobody's asked me that yet. I thought that's where Glenn was going to go. So let me answer the question I wish I'd been asked. Actually, I'm going to answer the question that I didn't wish I was asked, and then I'll answer so what I'm not talking about is waterboarding. I'm not talking about the more coercive interrogation techniques that were part of the CIA program, like sleep deprivation, forced nudity, things like that. My basic argument is if a technique is lawful in the law enforcement context, if the FBI can do it, then the CIA ought to be able to do it as well, at a minimum, right? So what I'm talking about is rolling back some of these more restrictive Army Field Manual limitations that are appropriate in the armed forces context, but that actually are not observed in the law enforcement context, and I don't think should be observed in the intelligence context either. So those are the two questions I wish I'd been asked.
You did very well.
Thank you.
Asked and answered.
I just want to chime in here. So one of the oddities of, talking about what the CIA is allowed to do is that, of course, the CIA is actually out of the detention business and therefore out of the custodial interrogation business largely. I mean, they still interview people, but there's no program anymore in which the CIA is holding people for strategic interrogation, and therefore that sort of, as a practical matter, these people, when we hold them, are held by the military. And one of the interesting questions that I've kind of nosed around about it is, what's the, when you read the field manual, it is striking, how restrictive some of the techniques are relative to what the FBI does all the time. And the question is, how do they function under that? And the answer actually turns out to be, I think, really interesting, and I think it's a largely untold story, in part because very few people have an interest in telling it. And I think the answer is that there's a great deal more flexibility under aspects of the field manual than the military particularly wants to advertise, or than human rights groups have really wanted to talk about, because everybody kind of agrees to love the field manual. And the White House, doesn't really have an interest, having said, hey, we've, gotten out of the business of nasty interrogations, of talking about the degree of flexibility that actually exists under the field manual. And specifically, there's an appendix to the field manual, which is Appendix M, which Steve alluded to, which Nathan alluded to earlier. Sorry, Nathan. In which, you can hold somebody, if you read in the negative inferences of Appendix M, you can hold for somebody for up to 30 days renewable in circumstances of some degree of sensory deprivation in certain instances, and certainly in great isolation. And one of the things, when you talk to people who were involved in the CIA program, one of the things that they say is, the techniques were interesting. People who are defensive of the program will say, well, we learned a lot about from the techniques. But the thing that really, really, really caused people to cooperate was just isolating them from other people for long periods of time and making them really dependent on you. And the thing is that basic capability is totally consistent with the field manual. And so I think that one of the things that's happened over the last several years is that people have realized that the thing that was ultimately most valuable about the CIA program was not the set of specific techniques. It was the atmosphere that you could create. And that is actually doable under the field manual. And I don't think a lot of people don't have really an interest in talking about it because, it's not, this administration isn't going around the world saying, hey, look, we don't really need to waterboard them because we have this really coercive environment that we've created. But I do think that's a lot of what's happened, and that, we've all sort of agreed that, we won't talk about it that way. The other thing is that after those 60 days are up, and Steve referred, this time really Steve, referred to the Warsami case, Warsami was held by the military for almost exactly 60 days before showing up in the criminal justice system. I don't know this for sure, but I don't think that's an accident relative to what's allowable under Appendix M of the field manual.
Thank you. Sir.
Scott Ream from the Constitution Project, and this is a question for both Steve and Ben. In light of the substantial progress that's been made against Qaeda over the last 10 years, as Secretary Panetta's referred to, and assuming we do figure out a way to withdraw from Afghanistan sometime in the next few years, what impact do you think those developments have on the continued ability to read the now 10-year-old authorization for use of military force to supply detention authority and other related authorities going forward?
All right, I guess I'll take the first shot. So I actually think this is where, in the long term, the NDAA might matter a lot. So the thing about the AUMF, it's always important. I always make my students actually read it because they're always shocked that it doesn't actually just say, go. Right, fight terrorism. Right, the AUMF had a specific authorization about the persons, organizations, and groups directly responsible for 9/11, and so I think there was the opportunity that you could argue eventually for some kind of attenuation or vitiation claim. Indeed, right, in her plurality opinion in the Hamdi case, Justice O'Connor specifically relies on the existence of substantial U.S. ground forces in Afghanistan as part of her explanation for why it's obvious that there should be detention authority. So in a world with just the AUMF, I could have seen an argument that once there was a formal withdrawal from Afghanistan, that the detention authority changed, maybe not ended, right, but certainly was largely restrained. There are two problems, right? The first problem is the Supreme Court's jurisprudence here is not particularly sympathetic. So there's a case I doubt very many of you have heard of called Ludecky versus Watkins. Just from 1948, and Ludecky basically says wars aren't over until the president says they are. Right, so President Bush flies into has a mission accomplished flag behind him because mission accomplished isn't saying the war is over. Right, so the fact on the ground may be irrelevant if the administration continues to say we are in a state of armed conflict with Al Qaeda. But in any event, right, more importantly, I think the NDAA really changed the calculus. Because if you read the detention provision in the National Defense Authorization Act carefully, Section 1021, it refers both to individuals who were part of the organizations responsible for 9/11 and to folks who were involved in other affiliated hostilities, right? Associated forces, hostilities elsewhere in the globe, and it actually severs the direct requirement of some connection to 9/11 as a basis for detention authority, right? So I actually think this was, we have different views on what were the sneaky things in the NDAA. I think the most sneaky important thing in the NDAA was unhooking detention authority from Al Qaeda and from 9/11. And so, opening the door to sort of long-term detention of folks who are affiliated with other groups involved in other terrorist operations elsewhere in the globe. AQAP, Al-Shabaab.
I agree with that almost entirely, and would just add that the nuance that it, I think, depends to a certain degree on how you envision the disengagement with Afghanistan taking place. So if you imagine we pull out some number of tens of thousands of troops and have a small number of troops and we fly drones over there and we're still attacking the same people and we're giving aerial support to and ground support and logistical support to Afghan forces, I think it probably has no implications for the administration would still be able to say we're engaged in an armed conflict, right, and against the same people. There's modalities of it have changed, but we're still entitled to detain the enemy. The question is a lot more complicated, in my view, if you imagine, for example, negotiations with the Taliban yielding fruit and some agreement that terminates hostilities in some sense. And then I think you're in a very, very different ballgame. That does not affect the Al-Qaeda side of detention, but you could imagine a negotiated end to the part of the conflict under the AUMF that involved the Taliban. And that would have implications for a large group of detainees at Guantanamo and elsewhere who are held pursuant to that portion of the conflict. So with that caveat, I agree with everything that Steve said.
I'm going to jump in, if I could, and just add a separate piece, and I agree almost entirely with both of them, except to add that I think one of the driving forces for the NDAA was to reset the detention clock.
Yep.
And to clarify the targeting piece. Because if you read the bold, the bare language of the AUMF, it's fairly doesn't say anything about detention, doesn't say anything about targeting, as you know. And so I think it resets the clock. And I want to pick up on Ben's point about the negotiations with the Taliban. I think it, of course, obviously leaves out the al-Qaeda piece, but then I think you got to question whether or not the broader language of the NDAA. And by the way, Steve and Marty Lederman did a really good two-part series on Lawfare blog called The Good, the Bad, and the Ugly, which I recommend to all of you.
Actually, it was called The Good, the Bad, and the Laws of War.
Ah, well, whatever. Good stuff. And you got to ask questions like, was Congress looking at things like Boko Haram or LET or ACAP or other organizations that have loose or close, depending on your point of view, ties to al-Qaeda, and anticipating the next 10 years as Ben dangerously did. I mean, by the way, Ben's predictions, I would put a whole $1 on that, his predictions.
With a vote of confidence like that.
Yeah, because I think he could be right, and I think he could be wrong.
But this is kind of say, I mean, this is why I actually think the media and a lot of sort of public commentators have had the exact wrong story about the NDAA, right? I mean, the NDAA as a sort of public discourse issue has been framed as, suspending the Magna Carta, right? Detaining Americans domestically,
Right.
When in fact it literally doesn't authorize that. It's not that it doesn't say anything. It literally says we say nothing about citizens or other persons picked up in the United States. Where the NDAA is going to matter on detention questions is in exactly the opposite case, right? Which is to say non-citizens picked up in non-traditional contexts going forward. Because that's where I think, Scott, you would have had arguments that the AUMF really couldn't continue to authorize new detentions of that kind in perpetuity, and the NDAA doesn't just reset the clock, right, which I think is right, it broadens the net in ways that I think have not yet been material in a single case, but could very well be as things develop going forward.
A follow-on to that was handed to me. A follow-on to this question, a kind of broad one, with probably the last question as we get ready for Judge Chertoff at lunch. How does any of this we've discussing today for the second decade of the war on terrorism, perhaps not just al-Qaeda, if al-Qaeda has been disrupted to the point of being ineffective internationally, how does any of this apply to Iranian-backed Hezbollah actors preparing for attacks within the United States? So it's a natural follow-on to what was just being discussed, but certainly some complex legal issues there as well.
Well,
Ellie? Oops.
So, I mean, I think, Congress did not authorize the use of force against Iran. It did not authorize the use of force against Hezbollah. Other than, I don't think anybody has made, at least not from either this administration or the last, a serious public case that either is meaningfully co-belligerent with or an associated force with organizations with which Congress did authorize the use of force. Now, you could imagine under certain circumstances that circumstance changing, and you could imagine, I suppose, in the context of some future geopolitical, I guess the technical term would be mishegas, a different congressional authorization of the use of force that would encompass those organizations. I don't see how you can, and I don't think it would be the slightest bit advisable to try to jerry-rig use of force against Hezbollah or Iran under the 2001 AUMF.
Right. I mean, I think it would have been a slam dunk question under the AUMF that there's just no plausible argument. I think it's not a slam dunk question under the NDAA. I'm with Ben, right? The argument has not yet been made that Hezbollah is an associated force within the meaning of Section 1021. Give me the right facts, right? And I'm sure we'll find someone trying to make that argument. But more importantly, I mean, this maybe sort of ties back with one of the points I made before. Hezbollah is, I'm pretty sure, a designated FTO.
Yeah.
Right.
It
And
is.
so you know, there are a wide range of ordinary criminal remedies and penalties available for the government for anything that happens inside the domestic United States, even for things that happen overseas. Now that the material support statute applies extraterritorially. So, you know, in fact, we have continued to operate under this paradigm where if it's not Al-Qaeda or its co-belligerents, we leave it to the ordinary criminal justice system. Of course, an attack could change that, right? But, you know, that's where we are.
Anything else? Okay, we're just about coming time for breaking for lunch, but I did want to again thank the panel and for their wonderful.
Good luck this afternoon.
Yeah, thanks. Always fun.
I think we could talk all day, but I did want to again thank the Federalist Society. When we talk about national security law, and we'll be continuing the afternoon after lunch, one of the items that is celebrated by the Federalist Society, which I appreciate, is their appreciation for the military, because the policies, these four people, regardless of what happens in November, will likely be thinkers and policy generators for military actions and the laws affecting those in the military. And I know we have here at least Admiral is here, Captain Bob Hayes from the Coast Guard, and Colonel Holly O'Grady. And I think it's appropriate we give a round of applause to our men and women who are in the service implementing these policies.